Today we're going to go over the South Carolina Disclosure of Real Estate Brokerage Relationships document put out by the South Carolina LLR. And I'm going to take it in sections like we typically do. So you'll be seeing this on your screen. You'll be seeing highlights of certain things, and we'll be stopping at each section so you can jump to the section where you want to have more information on. So we're going to take it. And we're going to start right at the beginning. And we'll read it together. So it says, pursuant to South Carolina Real Estate License Law, in South Carolina Code of Law, Section 4057-370, a real estate licensee is required to provide you a meaningful explanation of agency relationships offered by the licensee's brokerage firm. This must be done at the first practical opportunity when you and the licensee have substantive contact. So what is substantive contact? It's basically anytime you make contact with somebody and instead of talking about their family and their children and their dogs or their pets, you're actually moving the conversation into, for example, oh, you're wanting to buy a home. Well, what are you looking for? Are you wanting to look at homes? Are you wanting me to set you up in the MLS? Have you ever thought about signing an agency relationship contract? Have you signed an agency contract with another real estate agent? When you start talking about more substance of a real estate transaction, you really want to stop and say, hold on, South Carolina needs me, or it requires me to explain the disclosure of brokerage relationships form to you and also provide you a copy of it so you have a total and complete understanding of what agency is, what customer service is, and what client level service is, and honestly, what transaction brokerage is, which is new for South Carolina, which took place January 1st, 2017. In the next section, it goes on, it says, before you begin with a real estate licensee, it is important for you to know the difference between a broker in charge and associated licensees. The broker in charge is the person in charge of a real estate brokerage firm. Associated licensees may work only through a broker in charge. So in other words, when you choose to work with any real estate licensee, your business relationship legally is with the brokerage firm and not with the associated licensee. So as I am the broker in charge, all of the associated licensees here at this particular office work underneath my license through the LLR. And basically, I like to use the term I knight, for example, any licensees coming in to work here to work on my behalf, your business. A real estate brokerage firm and its associated licensees can provide buyers and sellers valuable real estate services, whether in the form of basic customer services or through client-level agency representation. The services you can expect will depend upon the legal relationship you establish with the brokerage firm. It is important for you to discuss the following information with the real estate licensee and agree on whether in your business relationship you will become a customer or a client. So when you're talking about this document with the customer at that point, it's your responsibility to make sure they have that meaningful explanation and to make sure that you establish whether or not they want to remain a customer and go under transaction brokerage or become a full client in which you would fill out a exclusive right to buy contract with that particular client. Let's stop here. Let's get ready to go into the next section entitled, You Are a Customer of the Brokerage Firm. Once you start speaking with anybody, no agency relationship has been established. Everybody in South Carolina, if they do not have an agency relationship, is considered a customer. Everybody's relationship starts out as being a customer. South Carolina license law defines customers as buyers or sellers who choose not to establish an agency relationship. The law requires real estate licensees to perform the following basic duties. So here is our requirements when dealing with any real estate buyer or seller as customers. Here they are. Present all offers in a timely manner. Account for money or other property received on their behalf. Provide an explanation of the scope of services to be provided. To be fair and honest, and provide accurate information. This is the big one that we did not have prior to January 1st, 2017. Provide limited confidentiality and disclose material adverse facts about the property or the transaction which are within the licensee's knowledge. Limited confidentiality is the big one. And what you must understand about limited confidentiality is in no way, shape, or form can you disclose to anybody outside of that customer the customer's motivation on price, terms, or any other motivations whatsoever. We have a hard time sometimes understanding this because prior to January 1st, if you had a client relationship with a seller and you did an open house and a buyer walks in that's a customer and the buyer told you that even though this is a $200,000 listing, I think I want to offer $180,000, for example. But I know the house is probably worth $200,000. So I'm willing and I would go up to $200,000. Prior to January 1st, 2017, basically, if we had an agency client relationship with that seller, we were allowed to go back and speak to our seller and say, listen, the buyer came in and told me that they were willing to go up to $200,000. So I don't think I'd be taking $180,000 for this house if they're willing to do that. Now we cannot. After January 1st, 2017, that is all changed. Again, limited confidentiality. We cannot disclose even to our clients price, terms, or motivation. It goes on and says, unless or until you enter into a written agreement with the brokerage firm for agency representation, you are considered a customer of the brokerage firm, and the brokerage firm will not act as your agent. As a customer, you should not expect the brokerage firm or its licensees to promote your best interest. We cannot advise a customer. We can provide extra services, but they're not automatically allotted that as a customer. The LLR has a transaction brokerage document, which we're going to talk about in just a second, that you can actually write in other services that you will provide under transaction brokerage. However, there's some nuances about transaction brokerage that we have to understand. Customer service does not require a written agreement. Therefore, you are not committed to the brokerage firm in any way unless a transaction brokerage agreement or compensation agreement obligates you otherwise. Our brokerage allows transaction brokerage for buyers/sellers. It does not allow transaction brokerage for listing a property. We can't do transaction brokerage if we're going to list a property in MLS, but we can surely go out and do a transaction brokerage on a for sale by owner and have a buyer customer in that transaction where the seller signs a transaction brokerage agreement obligating them to pay us or the brokerage for bringing a buyer to their house, and the buyer can remain a customer. So we're going to talk about transaction brokerage and kind of the nuances of that here right now. So let's talk about what the disclosure says about transaction brokerage, and then we'll break down the two transaction brokerage agreements that you have in zip forms. Let's read it together. So it says, a real estate brokerage firm may offer transaction brokerage in accordance with South Carolina Code of Laws, Section 4057-350. A transaction broker means a real estate brokerage firm that provides customer service to a buyer, a seller, or both in a real estate transaction. A transaction broker may be a single agent of the party in a transaction, giving the other party customer service. A transaction broker also may facilitate a transaction without representing either party. The duties of a brokerage firm offering transaction brokerage relationship to a customer can be found in South Carolina Code of Laws, Section 4057-350, subsection L, subsection 2. In zip forms, there are 2 transaction brokerage agreements. I'm going to put them up on the screen. One of them is this form, and it is directly from LLR. It says Transaction Broker Agreement. And this is a pretty simple form to fill out here. Remember what I said before. You only need a transaction brokerage form if the party is obligated to pay you for services rendered. So for example, again, if you have a customer for sale by owner, and you're going to bring a buyer to their house and they have agreed to pay you, transaction brokerage form would be filled out on that scenario. Because the for sale by owner saying, yes, I will pay you. If you bring my property to closing and you bring me a buyer, I'll pay you whatever. This form would be used. If you're working with a customer buyer and the for sale by owner says, no, I'm not going to pay you whatsoever. And the buyer says, well, I still want this house. I still need your help. I will pay you for your services. At that point, you could use a transaction brokerage agreement for the buyer becoming obligated to pay you or saying that they're going to pay you. So there's a few different reasons for this form. I do want to make reference, though, that I like and I prefer the LLR document over the SCAR document, which is on the screen now. And there's a few different reasons, but let's look at the LLR document first. It simply says, as a transaction broker, the real estate brokerage firm blank, that would be your company, will assist the customer blank, that's the name, under the following terms. Customer agrees to compensate the transaction broker. The amount of compensation shall be dollar amount or percent. Again, I like dollar amounts. I don't like percentages, but you have the opportunity to choose either one there. Of the selling price plus appropriate sales or service tax, which may be satisfied in whole or in part by payments from a cooperating brokerage firm or party to the transaction. Number 2, standard terms. Customer agrees that a transaction broker is not an agent of the customer. We've already discussed that a little bit. You're either a customer or you're a client, and at that point, if you're a client, you're an agent of that person. Customer has not established a client relationship with the transaction broker, and the transaction broker is not acting in a fiduciary capacity to the customer. B, customer agrees that transaction broker is not an advocate for the interest of the customer. You can't advise them. You don't have to be loyal to them. You don't have to obey them. You just have to do your part. Present the offer timely, use care, and other things that come along with being a customer that we've already discussed. Customer transaction broker agree that transaction broker will assist the customer as outlined in the description of services offered segment of this agreement, which you'll see the lines below. And then D, customer agrees that transaction broker will act under limited confidentiality, which we've already discussed. You can't discuss price, terms, and motivation, but it's going to go on in detail here about it, and will not disclose, it's bulleted, if customer is the buyer, information concerning customer's motivation to buy or willingness to make a higher offer other than the price submitted on a written offer. So taking that example again, you're a listing agent, a buyer walks in that's a customer, you're the listing agent of the property, it's at an open house, and buyer says, I know this house is listed for $200,000. I want to make an offer at $180,000. But if they don't accept it, I am willing to go up to $200,000. You can't go back as a listing agent to the seller and tell your seller that under limited confidentiality. If customer is the seller, factors motivating the customer to sell are willingness to accept an offer less than list price. So if the customer was the for sale by owner and they're involved in transaction brokerage, they're obviously have limited confidentiality too. You can't go back to the buyer and say, well, this seller is willing to come down. Basically is what they're trying to say there. That customer as a seller or buyer will agree to financing terms other than those offered. Again, it's price, terms, and motivation. You cannot discuss in limited confidentiality. And then the last bullet, information requested by customer to remain confidential except information required by laws to discuss or to be discussed. There are certain things that we are required to disclose. For example, if you know there's a problem with something in the house, you know that the law says that you are to disclose that. Anything that you know about the property, that's a problem. On the South Carolina form, it says on that same basic bullet point, keep information confidential as requested in writing by the customer. And then it goes on, customer agrees to waive all confidentiality except for that information the customer requests in writing be kept confidential. Well, there's a little bit of a catch-22 here because the LLR document, let me go back, says information requested by a customer to remain confidential except information required by laws to be discussed. So I, as a broker, prefer the LLR document. It says we're supposed to keep information confidential. That's what I want to go by. So that's what I'm going to really push and really recommend for agents to use the LLR document. I just prefer that over anything, and it's because of the way it's worded there. So we're going to stop here, and we're going to continue on to the next session. You can become a client of the brokerage firm. Let me go back and let me refresh your memory on basic duties for a customer. Right on the very first page, it says basic duties are that we are to present all offers in a timely manner, account for all money or other property received on your behalf as the client, or correction, as the customer, provide an explanation of the scope of services to be provided, be fair and honest, and provide accurate information, provide limited confidentiality, again, there it is, and disclose material adverse facts about the property or the transaction which are within the licensee's knowledge. So everybody gets those basic duties. But when somebody, a customer, decides to become a client of the brokerage, they're going to get some other duties that we as realtors, we as licensees, have to provide when they become, when they sign a agreement to become a client. Let's start out. It says clients receive more services than customers. If client status is offered by the real estate brokerage firm, you can become a client by entering into a written agency agreement requiring the brokerage firm and its associated licensees to act as an agent on your behalf and promote your best interests. If you choose to become a client, you will be asked to confirm in your written representation agreement that you received this agency relationships disclosure document in a timely manner. So on a listing agreement, on an exclusive right to buy agreement, one of the very first things that a buyer is going to initial is that line that says the client was provided a meaningful explanation of the disclosure of brokerage relationships form when that time was needed to do so. It goes on, it says a seller becomes a client of a real estate brokerage firm by signing a formal listing agreement with the brokerage firm. For a seller to become a client, this agreement must be in writing and must clearly establish the terms of the agreement and the obligations of both the seller and the brokerage firm, which becomes the agent for the seller. Otherwise known as the standard listing agreement, exclusive right to sell agreement, which we use here at this firm. A buyer becomes a client of a real estate brokerage firm by signing a formal buyer agency agreement with the brokerage firm. For a buyer to become a client, this agreement must be in writing and must clearly establish the terms of the agreement and the obligations of both the buyer and the brokerage firm, which becomes the agent for the buyer. In both agreements, it lays out terms that the brokerage and the associated licensee is going to do, and what the buyer or the seller, their obligations are. So both parties, the agent or associated licensee, broker, and the buyer or seller, they both have duties in the agreement that they're supposed to fulfill. Let's continue on with the second page of the agreement. It says, if you enter into a written agency agreement as a client, the real estate brokerage has the following client-level duties. These are added to the basic duties that every customer gets, which we did right at the beginning of this section, where I reminded you of. Client-level duties are obedience, loyalty, disclosure, confidentiality, accounting, and reasonable skill and care. Remember in your real estate classes, old car. That's the acronym for all of these client-level duties. Client-level services also include advice, counsel, and assistance in negotiations. Remember in transaction brokerage, if you're only a customer, if the person is only a customer, you cannot advise, you cannot counsel. You can only do those basic duties unless the customer and you come to a written agreement stating that you're going to do others on such behalf. Okay, let's stop here and then we'll go on to the different types of agency. So I'm not going to spend a whole lot of time on the different types of agency, but we are going to read them just to make sure you have an accurate understanding and knowledge of what they are. I would probably venture to say that most agents know this, but it's always good to have a refresher and just to read it verbatim as exactly what agency is. So looking here, in single agency, when the brokerage firm represents only one client in the same transaction, the seller or the buyer, it's called single agency. So what's an example? If an associated licensee or if you have a buyer client and you go and you guys make an offer on another property outside of the brokerage, that is called single agency. That's pretty self-explanatory. One brokerage is representing the seller. Our brokerage will be representing the buyer. Single agency, very easy to understand. Dual agency. Dual agency exists when the real estate brokerage firm has two clients in one transaction, a seller client and a buyer client. At the time you, basically the party, the customer, sign an agency agreement, they become a client at that time, you may be asked to acknowledge whether you would consider giving written consent allowing the brokerage firm to represent both you and the other client in a disclosed dual agency relationship. The buyer and the seller both have the ability to say yes or no to whether they will do or be in dual agency or not. Many sellers want complete and total representation. They do not want their listing agent representing their buyer or a buyer as well to buy their house. They want complete and total client level duties, especially when it comes to confidentiality. Same thing with buyers. If you want full representation without it being limited in dual agency, that buyer only wants to deal with that agent and does not want to have anything else hindering the duties that they're obliged to, then they may not want to do dual agency. But they have the right to choose at the time when that comes up. They don't necessarily have to make that decision right then and there, because both agreements, the exclusive right to sell and the exclusive right to buy, says you'll consider it at the time. It's not necessarily no right then and there and everything is off limits at that point. So let's go on. Talk about disclosed dual agency. This is going to give a little bit more information about how we as the agents have to handle it. In a disclosed dual agency, the brokerage firm's representation duties are limited because the buyer and seller have recognized conflicts of interest. Both clients interest are represented by the brokerage firm. Obviously, you could see where this could be a gray area. As a disclosed dual agent, the brokerage firm and its associated licensees cannot advocate on behalf of one client over the other. You can't put one person in front of the other if you're involved in dual agency, and cannot disclose confidential client information concerning the price, negotiations, terms, or factors motivating the buyer/client to buy or the seller/client to sell. Each dual agency agreement contains the names of both the seller clients and the buyer clients and identifies the property. So if you're involved in a dual agency situation, there is a dual agency agreement form which both the buyer and seller and the broker has to sign. Everybody has to know that this is a dual agency situation, and they can either say yay or nay at that point because they're considering it at the time. Going on to designated agency. In designated agency, a broker in charge may designate individual associated licensees to act solely on behalf of each client. Designated agents are not limited by the brokerage firm's agency relationship with the other client, but instead have a duty to promote the best interests of their clients, including negotiating a price. The broker in charge remains a disclosed dual agent for both clients and ensures the assigned agents fulfill their duties to their respective clients. At the time you sign an agency agreement, again, the customer or client, you may be asked to acknowledge whether you would consider giving written consent, allowing the brokerage firm to designate a representative for you and one for the other client in a designated agency. Each designated agency agreement contains the names of both the seller clients and the buyer clients and identifies the property. So basically, here's the example. If this office has a listing and a buyer is working with another agent under this office or this firm or this brokerage, we're a little bit different because we have separate brokers in charge over all of our offices. But in a general standpoint, if you work for a brokerage and the listing is held by the brokerage and a buyer is also being represented by an agent of that same brokerage, that's called designated agency. The broker handles it by dual agency because the broker is responsible and has a client level relationship with each party. The agents handle it as designated and have to be confidential with their respective clients on both sides, and therefore cannot come together and speak to one another about the confidentiality of their respective clients. So this happens quite a bit. Don't see a whole lot of issues with this. We see a lot more issues with dual agency because some people have a tendency to believe that you're not keeping their confidentiality as you should, and therefore it becomes a gray area and a conflict of interest. So some agents decide to do dual agency, some agents don't. Either way, up to you. Just make sure that you completely understand the differences and what you can and can't do. We'll go on to the next section about It's Your Choice here in just a second. In this next section, it's your choice. This is referring to it's the choice of the customer, whether they want to remain a customer or whether they want to have client level services. Let's read it so we exactly know what it says. As a real estate consumer in South Carolina, it is your choice as to the type and nature of services you receive. You can choose to remain a customer and represent yourself with or without a transaction broker agreement. Let me remind you again. This firm only requires a transaction brokerage agreement from the party obligated to pay them. So you can help a customer all day long if without any written agreement, if they're not the ones obligated to pay you. That's pretty self-explanatory. You can choose to hire the brokerage firm for representation through a written agency agreement, the exclusive right to sell, the exclusive right to buy. That's what they're referring to. If represented by the brokerage firm, you can decide whether to go forward under the shared services of dual agency or designated agency, or to remain in single agency. Remember, they consider that at the time. You sign a designated agency form, and you have to sign a dual agency form, whatever situation you're involved in. So there's forms for both of those situations. Let's go on. If you plan to become a client of a brokerage firm, the licensee will explain the agreement to you fully and answer questions you may have about the agreement. What are they saying? don't just hand the person the exclusive right to buy or the exclusive right to sell and say, here, read this and sign right here and let's move on. You really need to take the time to fully explain and make sure that your client at that point completely understands what they're signing. Remember, however, that until you enter into a representation agreement with the brokerage firm, you are considered a customer, and the brokerage firm cannot be your advocate, cannot advise you on price or terms, and only provides limited confidentiality. Everybody gets limited confidentiality unless a transaction broker agreement obligates the brokerage firm otherwise. If the customer says, you can tell them this, then that would be in writing. Hey, the customer said I can tell you that they're willing to do this, but this is what they're offering, or they're willing to do this, or we're going to do this on behalf of the customer to give them an extra level of service. The choice of service belongs to the party, the customer. The South Carolina real estate consumer is what this says. And then it goes on, it says acknowledgement of receipt by consumer. We cannot in any way, shape, or form obligate or force anyone to sign this form. Remember, the LLR protects the public. SCAR protects us as agents. The LLR protects the public from things that they don't even know. So we cannot obligate them to sign this form. Even in that little block that's grayed out there that says this document is not a contract, this brochure has been approved by the South Carolina Real Estate Commission for use in explaining representation issues in real estate transactions and consumer rights as a buyer or seller. Reprinting without permission is permitted, provided no changes or modifications are made. It's not a contract. However, some people coming in from out of state, they may not understand that. They may not even understand that in South Carolina. They think if they're signing something, it's automatically a contract. We're trying to let them know it's not a contract, but some people still may refuse. If somebody refuses to sign this, all I'm asking is that you document the date, time, and the place that this document was explained to that person, and keep this in your files in DTR or whatever your file structure may be. So I hope that explains the South Carolina disclosure of brokerage relationships. And I hope you have a full understanding of that now. And if there's any questions, by all means, let me know, comment, or whatever the case may be, send me an email. I hope I explained it, and I did explain it to the best of my ability. Remember, here's my disclaimer. I am not an attorney. I cannot interpret what the attorneys interpret. I cannot give attorney advice. I'm strictly a broker in charge, trying to get the best information and knowledge out to the agents that not only work here in this office, but also any agents that have a question about it as well. But in any case, remember always, especially if you don't work for me or under this office, if you work for a different broker, please make sure that you contact your broker and ask them anything. If you don't understand something or you think I said something wrong, please go to them and let them advise you on that. Because obviously, again, I'm not God. I am capable of making all sorts of errors. I hope I didn't, but if I did, please make sure that you talk with your broker about that as well. Hope you have a great day. Look forward to the next training video. Take care.